The IRS whistleblower who has the goods on the Biden crime family confirmed in a new letter that the DOJ and the IRS have been protecting Hunter Biden for years. Big surprise. They seem to still be doing it, having retaliated against the whistleblower who recently revealed the crime family cover-up. We're going to read through the letter and the emails that were sent by the whistleblower to the commissioner of the IRS. But first, let's get some more background from justthenews.com. They tell us the following. They say last week, attorneys for an IRS supervisory special agent, the IRS whistleblower, informed Congress that the DOJ had removed their client, taken the whistleblower and his entire team off of their investigation into the Biden crime family, calling that an act of retaliation. The whistleblowers come forward. They say, we've got some problems with how things are working in our agency. They talk to Congress about it. The agency comes back and says, oh, you're done now. You are removed. How dare you bring our internal operations over to Congress? So the whistleblower came forward in late April, alleging that federal prosecutors had engaged in preferential treatment and politics to stop charges from coming against Hunty. The whistleblower further alleged that his entire team had then been sidelined after he made the disclosures. He also asserted that Biden appointees had limited the ability of the so-called independent prosecutor that they appointed to investigate all of this, called David Weiss, to pursue charges against his son by refusing to grant Weiss the permission to do it in their jurisdictions. So these claims undercut testimony saying that these people have full ability to prosecute and to make decisions and all of that. We know it's nonsense. But the letter from the whistleblower's counsel got sent over to the IRS, and let's take a look at it. Sent May 20th, 2023, to the Honorable Daniel Werfel, Commissioner at the IRS. The whistleblower's lawyers, writing from Empower Oversight, Nixon Peabody, they say, Dear Commissioner, we represent the special IRS agent, the whistleblower, named Redacted. 5 days ago, you, the commissioner, were copied on a letter to various committees of Congress warning that the IRS had removed our client's entire team of investigators from a criminal tax case in an apparent act of retaliation aimed at some of those employees who had expressed concerns that the DOJ improperly allowed politics to infect its decisions. This action was consistent with your testimony. When you spoke to Congress, you said that there would be no retaliation against whistleblowers at the IRS. It was our understanding that although the IRS executed the reprisal, they removed our whistleblower, it did so on behalf of the DOJ officials who had the motive to retaliate because it was the propriety of their own actions that had been called into question. In other words, the whistleblowers were implicating DOJ officials, and so the whistleblower got removed because those DOJ officials put pressure back on the IRS to make a change in the investigatory team. The lawyers say, yesterday we became aware that even after receiving the May 15th letter, the IRS has inexplicably decided to initiate additional reprisals against these agents, apparently for a protected disclosure made directly to you, Commissioner. This is unacceptable and contrary to the law, which prohibits that. Our client learned that one of the agents he supervises, the case agent on the case our client is blowing the whistle on, sent you an email in which he wrote the following. Another whistleblower related individual, a case agent, sent a letter to the IRS. Says, Mr. Commissioner, as I'm sure you're aware, I was removed this week from a highly sensitive case after nearly 5 years of work. There is a human impact to the decisions being made that no one in the government seems to care about or to understand. To ultimately be removed for always trying to do the right thing is unacceptable in my opinion. My leadership above my direct manager, who was also removed, didn't even give me the common courtesy of a phone call, did not afford me the opportunity of understanding why this decision was made, and did not afford me the opportunity to even explain my case. If this is how our leadership expects our leaders to lead without considering the human component, that is unacceptable, and you should be ashamed of yourselves. For the last couple of years, my SSA and I have tried to gain the attention of our senior leadership about certain issues prevalent regarding the investigation. I have asked for countless meetings with our chief and deputy chief, often to be left out on an island and not ever heard from. The lack of IRS senior leadership involvement is deeply troubling and unacceptable. When I said on multiple occasions that I wasn't being heard and I thought I wasn't able to perform my job adequately because of the actions of the U.S. Attorney's Office and the DOJ, my concerns were ignored by senior leadership. The ultimate decision to remove the investigatory team without actually even talking to that investigatory team, in my opinion, was a decision made not not to side with the investigators, but to side with the U.S. Attorney's Office and the Department of Justice, who have been saying for some time has been acting inappropriately. We've been telling you that for years. Now, in response to making his good faith expression of reasonable concerns, this is the lawyer speaking, concerns shared by our client, the case agent had a right to expect his email would be taken seriously, that it would be considered, it would be addressed professionally and done without retribution, as the law requires. But instead, the IRS responded with accusations of criminal conduct. How dare you blow the whistle? You're violating the law. We're going to have you arrested and put in solitary. And warnings to other agents in an apparent attempt to intimidate into silence anyone who might raise similar concerns. Don't you even think about blowing the whistle on us. Specifically, the special agent in charge emailed the case agent suggesting without any basis that he might have a legally disclosed grand jury material in his email. What access did you get? Oh, what documents did you send to your lawyers? Your whistle? Oh, broken laws. You're going to be investigated now. While such a claim, his lawyers say, is utterly baseless and without support in the law or the facts of this matter, the language of the response suggests the case agent may have been referred for investigation over to the DOJ, an even more intimidating form of reprisal likely to chill anyone from expressing dissent. And furthermore, the acting special agent in charge issued a contemporaneous email to supervisors, including our client, admonishing employees to obey the chain of command, writing, there should be no instances where case-related activity discussions leave this field office without approval from your direct report. As commissioner, the lawyers say you are responsible by statute, by the law, from preventing prohibited personnel practices, including whistleblower retaliation. As the May 15th letter made clear, the salary of government officials can be withheld if they do something problematic, like preventing people from having contact with committees. This includes what you guys required, which is approval from their direct report. If they want to come meet with us, they can. You can't stop them from doing that. Our legal team has experience ensuring this provision was enforced against other agencies. Also says your agencies cannot prohibit or restrict employees. You cannot use funds to enforce a disclosure policy that complies with these prohibitions. And by the way, just so you're clear, you know it's a crime under U.S. law, Commissioner of the IRS, to obstruct an investigation of Congress. The House and Ways and Means Committee has the authority to investigate this. Do not interfere. Tells the IRS must immediately cease and desist intimidating our client for simply exercising his constitutional rights to petition Congress and his statutory right against retaliation for doing so. Please, IRS, immediately issue corrective guidance clarifying the aforementioned supervisor communications, lest they chill the disclosures of other whistleblowers who may come forward. Shout out to these seriously brave attorneys, Tristan Levitt and Mark Little, taking it to the commissioner of the IRS, copying Janet Yellen, Russell George, and Henry Kerger, special counsel's office, U.S. Department of Treasury, demanding that they stop silencing whistleblowers through policy changes intended to chill the exposure of their malfeasance. And the repercussions, the reprisals, and the retaliatory behavior continues as the Biden administration weaponizes the various institutions to protect the Biden crime family. IRS, DOJ, FBI, Department of Homeland Security, they all get brought in, but thankfully we have brave whistleblowers who are standing up and speaking out.